Today's lecture, we're going to be talking about the judicial branch. Article 3 of the Constitution creates the Supreme Court. Later on, we discovered that Congress created the lower courts, but I'll get to that in a few minutes. Who are these 9 people that are staring back at you? These are Supreme Court justices. These are the justices that are currently sitting on the Supreme Court making these decisions. Before we get started, you need to understand how our court system works. We have what is called an adversarial system, ADVERSIAL, an adversarial system. What's an adversary? An adversary is an opponent. It's a foe. It's an enemy. We have 2 sides that are going against each other. The first side, this side is called the plaintiff, 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 the plaintiff. The plaintiff is the accuser, the one making the accusation that they have been harmed in some way, shape, or form. The other side, the other party, is the defendant. The defendant is the one who has been accused. Our legal system exists to settle disputes. How do they do this? How do the judges decide cases? How do they decide who wins or who loses? Courts decide cases by hearing the facts on both sides of a dispute. So they hear the facts from the plaintiff and from the defendant. They will then apply the relevant law or the relevant principles to the facts. We have to realize that courts have authority over the citizens of the United States, but more importantly, they also have authority over the other 2 branches of government. Courts get to decide whether or not activities or laws, actions taken by the executive branch, actions taken by the legislative branch are constitutional or legal. Courts are obliged to maintain neutrality and impartiality when deciding disputes. They have to maintain fairness. They cannot be predisposed, or they are not supposed to be predisposed one way or the other. You're not supposed to pick one side to win, well, just because I like them better. The essence of the rule of law is that government officials are judged by the same laws as the citizens. So laws are supposed to be applied equally to elected officials and to us, the laymen, the everyday people. Court cases proceed under criminal law or civil law. So there's 2 types of law in the United States, criminal and civil. Criminal law. This is a branch of law that defines crimes and provides punishments for criminal activities. Criminal law deals with cases in which the government charges an individual with violating a statute, with violating a law that has been enacted to protect the public health, the safety, the morals, or the welfare of the people. In criminal cases, under criminal law, at the lowest level, we haven't gone over this yet, I'll explain this to you in a second, but at the lowest level, the lowest trial level, the lowest court level is the trial court, the trial level. At this lowest level, the government is always the plaintiff. They are always the accuser. At the trial level, why is the government always the accuser? because it is the government and only the government that has the authority to create law. We cannot accuse somebody of breaking a law if we did not have that authority to create it. If I am the victim of a robbery, can I accuse them of breaking the law? No, I did not have the authority to create a law telling people you cannot rob other people. That's only the government. That's those police powers. Now I can be a witness, I can be a victim, but I cannot be the plaintiff. So at the criminal law, at the trial level, the government is always the plaintiff. Punishment for criminal cases can involve fines, can involve imprisonment, incarceration, or it can involve both. Civil law. Civil law or civil cases involve disputes among individuals, groups, corporations, or other private entities. So civil case is going to be between individuals, businesses, that kind of thing. These cases are also going to involve plaintiffs and defendants. With civil law, we're talking, it could be contracts. It could be personal injury. It could be family law. Civil law involves a number of items. Punishment for these cases, punishment for civil law, differs than that from criminal law. Punishment often involves money, financial compensation, or punitive or punitive payments, punitive additional damages. I told you in criminal law, the government is always the plaintiff. I told you in civil law that these cases are mostly between individuals, companies, businesses, corporations. Can the government be involved in a civil trial, in a civil case? Yes, they can. What party can the government be? In a civil case, the government can be any party. They can be the plaintiff or they can be the defense. Can the government sue you? Yes, they can. Think about it. If you're a business owner and you're dumping toxic chemicals into the water source, into a water system, can they sue you? Yes. Can you sue the government? Can the government be defended? Yes. The government does something to harm you, you can sue the government. When deciding cases, whether it is for criminal law, whether it is for civil law, the courts will apply statutes, they will apply these laws, these relevant facts, but they also look at legal precedents. This is precedents. A precedent is a prior case whose principles and decisions are used by judges as the basis for the decision in present cases. This is called, Latin term, stare, S-T-A-R-E, second word, decisis, D-E-C-I-S-I-S. Latin phrase meaning literally, let the decision stand. Our court system, we try to maintain equality throughout the system, and this is actually very important to us. by the courts looking to the past. They are looking to previous court decisions to help the current judge, to help the current court guide their decision. They want it to be in line. They don't want it to be so obnoxious, so out of the norm that this court decision is going to be overruled by a higher court. Let me give you an example. Stare decisis. Precedent. You tell me which one should not happen. You have person A. They decide to become a business owner. They want to open up their own gas station. So they hire a general contractor to build their station, install the gas tanks, install the underground fuel storage tanks. General contractor hires the subs. They do all the work. They open up. About a year later, the state comes out to inspect this gas station. And it finds out that the subcontractors installed the underground storage tanks incorrectly. They're leaking fuel into the groundwater. The state fines person A, the gas station owner, $500,000. Person B, they also decide to go into business for themselves. They open their gas station. They hire the same general contractor who hires the same subs. They install the same material, which, can you see where this is going? Subcontractor who installs the underground storage tank installs it incorrectly. A year later, the state comes out, does their annual inspection on the gas station, and it is discovered that these underground storage units are leaking fuel into the groundwater. The state fines you, person B, $500,000. Person C, they decide to go into business for themselves. Can you decide what they're going to do? What kind of business they're going to open? I knew you could. They're going to open a gas station. Hire the same contractor who hires the same subcontractors. Same subcontractors install this underground storage incorrectly. It's leaking. A year later, state comes out for their annual inspection. They inspect it, discover it's leaking. They fine the person C, the third gas station owner, $2 million. Is anything wrong with this picture? Yeah, a lot. What's the main thing? Based on precedent, based on previous experience, what should the fine have been? Well, and for the first person, it was $500,000. For the second person, it was $500,000. So for the third person, it should have been $500,000. We do this, we individuals, we actually need precedent in the court system too, to make sure everybody is being treated equally. Types of courts include trial, appellate, and supreme. The United States judicial system. We are a three-tiered system. Write this down, study it, understand it. We are a three-tiered system. The lowest tier, the lowest level of court is called the trial court. Trial court has something called original jurisdiction. Mid-level, the appellate court. It's spelled right there, appellate. Say it a couple of times. I recommend I have my students in person say appellate, because if I don't, somebody's going to come up and ask me a question about the appellate court, and it's going to take me a few seconds to figure out what you're talking about. So appellate court. Appellate court has something called appellate jurisdiction. So trial level, the lowest level, they have original jurisdiction. Mid-level, out of these three tiers, the mid-tier, the appellate court, they have appellate jurisdiction. Third tier, the highest tier, highest court, is the Supreme Court, the court of last resort. The Supreme Court has both appellate and original jurisdiction. See anything else I want to say here? No, I think I'm good here. Let's talk about the Supreme Court. Article 3 of the Constitution is what gives the Supreme Court. Well, they create the Supreme Court, and they give this Supreme Court these two types of jurisdiction: original jurisdiction and appellate jurisdiction. Original jurisdiction. Original jurisdiction is the authority for the court to hear a case for the first time. This is where they're going to establish the facts of the case. This is where they're going to establish what happened. The Supreme Court, they have original jurisdiction in all cases involving foreign ambassadors. They have original jurisdiction in cases and there are issues in which a state is one of the parties involved. Now, appellate jurisdiction is the ability or the authority to review the decisions from a lower court. Our court cases, our court system, it operates under very strict rules of procedure. This appellate court, this appellate decision, the appellate courts have appellate jurisdiction, so this means that they get to review cases over the trial or from the trial courts. Their job is to make sure the trial court judges followed proper procedure. Okay? Supreme Court, their appellate jurisdiction, they get to make sure the appellate court followed proper procedure. Now, Article 3, we call it the legislative branch, but I stated a minute ago, Article 3 only creates the Supreme Court. But I have told you we also have a level for trial courts. We also have a tier, we have a level for appellate courts, this three-tiered system. So if Article 3 only creates the top court, if it only creates the top tier, where did these lower two courts come from? They come from Congress. Under authority from Article 1, Congress has the responsibility, they have the authority to create lower courts. So Congress creates these trial courts. Congress creates these appellate courts. Article 3 provides certain protections for the Supreme Court. And these protections are very, very important. These protections are lifetime tenure. Once you get put on a court bench, you serve for life. You can be removed if you did something illegal. You can be impeached if you have done something wrong. But other than that, you serve for life. You serve until you either die or you say, I quit. The second protection is that it offers pay protection. Congress cannot cut the pay of the court system. These are important. I'll explain why at the very end. Now, Article 3 gives these protections to the Supreme Court. Congress creates these lower two levels. They create the trial level, they create the appellate level. But these Article 3 protections have been extended to our trial courts, to our appellate courts. So even though they're created by Congress, they still find those same protections from Article 3, lifetime tenure, lifetime job security, and they cannot cut their pay. Now, we're going to get a little strange here. Congress can also create specialty courts. These are courts that handle certain types of cases. These specialty courts could be bankruptcy courts, immigration courts. We have a U.S. Court of International Trade. These are called legislative courts, Article 1 legislative courts, these specialty courts. They are not as independent as the Article 3 courts because they're judges. They don't have that protection. They don't have that lifetime tenure. They are appointed. They serve a 15-year term. So courts lower than the Supreme Court are created by Congress. The federal court actually hears a small percent of all cases. Guys, a lot of what I'm talking about now, if you have not taken Texas government, you really need to remember this. What you're going to find is a lot of things that I've discussed here, they apply to Texas government. Texas borrowed heavily from the federal government when we were setting up our state government. We have a constitution, we have 3 branches of government. Guess how many tiers, guess how many levels we have in the Texas court system? Gee, we have 3. Can you guess what they are? Can you guess what their jurisdiction is? So this is very important for you to remember through Texas government if you have not taken it yet. Okay. The federal courts hear a small percent of all cases. Why do we say that? Remember, basically, the federal government's job, protect property, promote commerce. The states do, or they did, and they still do, most of the heavy lifting, the heavy regulating. It is the states that create their own code of criminal conduct. In Texas, it's called the penal code. We have our own criminal laws. Each state has the authority to create their own criminal justice system, to create their own laws. Now, does the federal court or does the federal government have this authority? Yes, they can create federal laws, but these are overreaching, overarching laws. These are big laws. The state is the one that we are going to deal with on a day-to-day basis. This is why we say the federal courts hear a small percentage of all cases. In Texas, actually about 95% of all cases in the court system are in the state court system. Only about 5% of all cases are done at the federal level. The lower federal court handles most cases. So we're talking about the lowest level, the trial court. The trial court can also be referred to as the district court. the district court level. So if you hear trial court, if you hear district court, these are the same thing. This is the lowest level. Let's see, there are 94 district courts spread out across the United States. 94. That's it. They have authority. Jurisdiction can be authority. They have original jurisdiction, so they are going to be the court that hears the case for the first time. That's going to establish the facts. They have authority. They have jurisdiction over a certain physical area. If a crime, if something happens in one particular area, it's got to be filed. The case has to be filed in that jurisdiction, in that court's jurisdiction. If you have a contract that is violated in Texas, you cannot go file it at a district court in New York or in Pennsylvania or in California. It has to be filed in the jurisdiction in Texas of that court. Thank you. Sorry about that. So these trial courts, these district courts, they have original jurisdiction. I said it is the job. These trial courts, they have to follow proper legal procedure. Who is the person in charge of the court? The person that's supposed to make sure that proper legal procedure is filed. That's right, it's the judge. One judge per court, lifetime tenure. They serve as long as they want, and it's one judge per case. Do the federal district courts, do the trial courts, do they have to hear all cases which are filed in front of them? Yes, they do. These courts of original jurisdiction have to hear all cases. Now, does that mean that all of these cases that are filed are actually going to go to trial? No, it doesn't. In civil trial, in civil law, we have a number of cases that ends with mediation or arbitration. Both sides agree to go in front of this disinterested third party. When I say disinterested, they don't have any interest in the outcome. They don't benefit one way or the other. Now, both sides have agreed to this. They go to this arbitration, they go to this mediation to see if they can work out an agreement, work out a compromise. Both sides have agreed to abide by the decision of the mediator, the decision of the arbitrator. Why would you do this? If you're suing, if you have brought a civil claim against somebody, why would you agree to a compromise? Well, let me ask you. The wheels of justice, our court systems, do the wheels of justice spin quickly or do they spin slowly? It goes really, really slow. And you're still paying your attorney for all the work that they're doing during this whole time. So if you have a case that you have a choice, you can take your case to trial, and it might take 3 or 4 years to go to trial, or after 6 months, you can go to arbitration. 3 to 4 years for a trial, 6 months to arbitration. 3 to 4 years of paying an attorney, or after 6 months, do you have a compromise? Financially, which do you think is going to be better? Honestly, probably the mediator, probably the arbitrator. Probably going to save you money in the long run. So that's why people do it. Criminal court, Once again, most of these cases don't go to trial either. Why not? Most criminal cases end up with a plea bargain. A plea bargain is this negotiating session between the prosecuting attorney, between the government attorney. Remember, I told you, trial level criminal court case, the government is always the prosecutor. It is a negotiation between the government attorney and your attorney. It might be, okay, if you plead guilty to this, well, the punishment range is 2 to 10 years incarceration. If you're found guilty, you can get anywhere between 2 to 10. If you plead guilty today, we'll recommend the judge do the bare minimum. They sentence you to 2 years incarceration. They may lower the level of the offense so that the incarceration time is not as heavy, is not as long. They want you to plead guilty. You plead guilty, in exchange, you get a lesser punishment. So, but remember, the trial courts, they are obliged to hear. They have to hear every case that is filed before them. They have to accept it. It may end, we may not have a verdict. It may end in a plea bargain. It may end in a mediation or an arbitration. But the trial courts, these district courts, have to hear every case. The appellate courts. The appellate courts, they can also be called the Court of Criminal Appeals. They can also be called circuit courts. 3 terms: the appellate courts, Court of Criminal Appeals, circuit courts. They're all the same thing. We have, let me make sure I have this right, 13. We have 13 appellate courts spread out across the United States. Each appellate court has authority. They have jurisdiction, physical jurisdiction, over certain states. In Texas, we belong to the 5th Circuit. The 5th Circuit is located in New Orleans. It has jurisdiction over Texas, Louisiana, and Mississippi. So, if you are at the trial level and you lose, if you're in a civil court, civil trial, and you lose, if you are in a criminal court and you're the defendant, if you are the one being accused of a crime, and you lose, you can appeal that decision. You can state that the judge or that the lower court, the trial court, acted improperly. They did not follow proper legal procedure. So you can appeal up to the appellate court, that circuit court, Court of Criminal Appeals. Do the Court of Criminal Appeals have to hear your cases? Do they have to hear your appeals? No, they don't. They get to cherry pick. I said the lower courts, the district courts, had to hear everything. The appellate court, this mid-level court, they get to cherry pick. They get to decide which cases are going to hear. And they're only going to hear maybe 10% of these lower court cases. They're going to say, okay, yeah, there might be a constitutional issue here. Maybe the trial judge erred in their ruling. Maybe they did not rule correctly. We need to review it. So the court records are going to go up to the appellate court, the Court of Criminal Appeals. And no new facts, no new witnesses. The argument here is going to be why the lower court, or how the lower court judge messed up. Why you feel that the lower court judge ruled incorrectly. How was procedure not followed? Appellate court is a little bit different than the district court a couple of different ways. The district court, you have one judge, and there's not very much judicial involvement. What I mean by that is they really don't have legal discussions with the attorney for the plaintiff, with the attorney for the defense. They're just supposed to sit there and rule on legal procedure. You appeal. The appellate court, the circuit court, has decided to hear your appeal. It is going to be done in front of a 3-judge panel. So 1 at the district level, 3 at the appellate court. These 3 judges, they are going to interact with the attorneys arguing the case, with the plaintiff's attorney, with the defendant's attorney. They're going to ask questions. They're going to ask for clarification. They will be more involved. At the district court, trials can take forever. They can set 2 to 3 week trials. The appellate court, very strict guidelines, very strict time guidelines. Usually no more than a day. The plaintiff, their attorney, they will be given X amount of time to argue their case. The defendant will be given the same amount of time to argue their case. The plaintiff is then given a lesser amount of time to offer a rebuttal, to argue against what the defendant said. After that, the defense attorney is giving even less time to offer a rebuttal to the plaintiff's rebuttal, to offer an argument to what the plaintiff has just said. Once these 4 things have occurred, the actual trial portion of it is over. So very, very quick. You lose at the appellate court, I'm sorry to say. Well, all is not lost. You do have the opportunity to appeal to the Supreme Court. Now, to get to the Supreme Court, well, we'll get there in a second. The Supreme Court is the United States' highest court. Article 3 gives the judicial power of the United States to the Supreme Court. The court is made up of 9 people. We have the Chief Justice. The Chief Justice is the person who presides over the court's public session. Then we have 8 associate justices. So we have a total of 9 justices. Is one any more powerful than the other? No, they're not. Then why do we have a Chief Justice and 8 associate justices? Basically, this serves as a historical footnote. In the past, when we are talking about Supreme Courts, we refer to this Supreme Court by the justice's last name. So we may say that the Rehnquist Court ruled on this. The Berger Court or the Warren Court ruled on that. 40 years from now, when we're talking about the court case which legalized same-sex marriage, we'll be talking about the Roberts Court, because Chief Justice John Roberts was the head of the court when we decided this case. So they're all equal. They all have 1 vote. but the Chief Justice is a historical footnote. I said they have 9. What's special about the number 9? It's odd. That's a rude thing to say. I'm sure there's other things out there that think you are odd also. Oh, no, you didn't mean that in a bad way. You meant that it was just an odd number. Okay, we can accept that. It's odd. But so is 1, 3, 5, 7, 11, 13, 15, 17, 19. What's special about the number 9? The answer, not a thing, other than the fact that it is an odd number. There is nothing special about the number 9. So why do we have 9 Supreme Court justices? Because currently Congress has said 9 seems like a good number. Does it have to stay at 9? No. Congress could choose to increase the number of Supreme Court justices at any time. Could Congress choose to decrease the number of Supreme Court justices? Yeah, if it happens, we have 9 people now, and if it happened that we had 2 vacancies come up, maybe we have a Supreme Court justice pass away and then the second one resigns. So we're down to 7. Could Congress say, you know what, we're going to reduce the number from 9 to 7. That way we don't have to appoint anybody else. We're good to go. Yeah, Congress can reduce it. So currently have 9. No special reason other than Congress has said it's good. But Congress has the authority to increase it. They have the authority to decrease it. The Supreme Court judges, these are the Supreme Court justices, these federal judges. So at the district, the trial level, the appellate, the Court of Criminal Appeals. How do they get their job? Judges are appointed by the president, but the advice and consent power, they must be approved by the Senate. So federal judges are appointed by the president. They're confirmed by the Senate. Nominees are generally selected from among the more politically active members of the legal profession. Often, before the president makes a formal nomination, we will see something called senatorial courtesy occur. Senatorial courtesy is the president will he will involve the senator from that candidate's state, assuming that they are the same party. So once again, if we have a Republican president and we have an open trial, a district court bench in Texas, assuming that the senator from Texas, one of the 2 senators, is Republican, we'd have the Republican president go to the Republican senator and say, okay, Senator, you have an open trial bench. I would like your help. I would like to involve you in the decision-making process. It might be, here's a list of 3 people that I believe would make good district judges. Or it might be, Senator, can you give me a list of 3 or 4 people you think would be good judges, who you think are qualified to fill this position? Why do the presidents want to go? Why do they want to offer this senatorial courtesy? Why do they want to start off on the same page as the senator from that state? Well, remember, the president gets to appoint the judges, but these people don't get their job till they are approved by the Senate. So if you are involving the senator from the get-go, from the start, chances are really good when it comes time to vote on the confirmation that senator is going to support your choice, support the person, because they had a hand in picking them. So not only are they going to support your choice, but they're going to tell all the other senator friends, hey, this is a good guy, you should support him. What if you don't involve him? Maybe that home state senator will still support him. Maybe they won't. And if they don't support your choice, they're going to tell all their Senate friends what? Hey, don't nominate this guy or don't confirm this person. They are not qualified to hold a bench. They are not even qualified to be a dog catcher. So you as president are making it harder to get your nominations confirmed by using senatorial courtesy, by involving the U.S. Senator. You're going to make life for you and for your nominee much, much easier. You're going to increase the chance that the Senate approves your nominee. I want to talk about a position real quick called the Solicitor General. The Solicitor General is the top government lawyer in all cases before the Supreme Court when the government is a party. So if the government is the defendant, they are the plaintiff, whatever, in a case in the Supreme Court, the Solicitor General. This is going to be the person who argues the case in front of the Supreme Court. Oh, let me say, Supreme Court, it is the same process as the appellate court. Strict timeline, they interact. The only difference at the appellate court level, there are 3 judges, 3 justices. Supreme Court, you're arguing in front of all 9. Okay, so the Solicitor General is going to represent the United States. They're the attorney for the United States in all cases in which the U.S. is a party. Is the federal government, a party in all cases? No, there's not. There's oftentimes we have cases states against states, or we have individuals who have sued states for violating civil rights or for whatever reason. So, does this mean that when the United States government is not a party, does this mean that the the Solicitor General doesn't do anything? They just sit around on their butt? No, it doesn't. Even in a case where the U.S., the government, the federal government is not a party, the Solicitor General, the federal government, can get involved. And actually, any of us can get involved in using this format. Even if we are not a party to the case, we can still get involved. We do this by writing or by giving the court something called an amicus, A-M-I-C-U-S, curiae, C-U-R-I-A-E, an amicus curiae. I will now just refer to this as amicus, but an amicus curiae brief. Another Latin term means friend of the court. Individuals or groups who are not parties to a lawsuit, who are not either the plaintiff or the defendant, we can still get involved by filing an amicus brief with the court. This amicus brief is presenting additional facts. It is stating, hey, based on precedent, based on previous court rulings, this is how you should rule. So amicus brief can be filed by anybody, amicus curiae. The power of the Supreme Court is judicial review. One of the most important powers of the Supreme Court is judicial review. Judicial review is the power of the court to examine and, if necessary, invalidate or declare unconstitutional actions that were performed or undertaken by the legislative branch, by the executive branch. So we get to see judicial review acts of Congress. We get to see judicial review acts of the executive branch, so the legislative branch, executive branch. Judicial review also applies to actions by the states. Where do we find the power of judicial review in the Constitution? The answer is simply, we don't. It is nowhere in the Constitution. It is a power that was halfway offered, halfway taken by the executive branch to the judicial branch in the early 1800s. It was a court case called, I'm drawing a blank, Marbury versus Madison. Marbury versus Madison. Marbury versus Madison. President Adams, it is his last night. His last night as president. President Jefferson, candidate-elect Jefferson, is going to be sworn in the next day. So his last night, Adams' last night in power, he decides that he's going to kind of mess with President Jefferson, and he starts filling all these low-level government positions. He starts issuing all these commissions. The people that are in Washington, D.C., that he's appointing to these government positions, they receive their commission that night. The people that are located out of D.C., the commissions are signed and sealed, but they're set aside to be delivered at a later date. He goes to bed. President Adams goes to bed happy, thinking that he screwed over President-elect Jefferson. Next morning, President Jefferson is sworn in, and he looks around and he finds this piles of commissions that haven't been delivered. Well, in his opinion, since they were not delivered, these commissions weren't delivered, they are null and void because Adams is no longer in power. So he sets them aside and he's going to appoint his own people. Well, Mr. Marbury is a person who was going to be appointed to a position, who was appointed to a position by President Adams, but the commission was not delivered. He really wants this appointment. So he goes to sue. The name is Madison versus Marbury because Madison was the Secretary of State under Jefferson. But the Supreme Court, he goes to sue in the Supreme Court. Supreme Court says, we will accept this case if you, the executive branch, if you, the federal government, will accept our decision if it goes against you. To which the federal government says, yeah, we will. So see, it was halfway given, halfway taken. The Supreme Court says we will do this only if you, a branch, agreed to abide by our decision. So they took the power, and the federal government, the executive branch, said, yeah, we will accept your decision. We will make our branch subservient to you. So, judicial review, not found in the Constitution, found in a court case called Marbury versus Madison. What are decisions based on? No, let's go ahead and move on. Most cases reach the Supreme Court by appeal. Does the Supreme Court have to hear every case that's appealed to it? No, once again, they don't. I told you that there are 13 district courts and they got to cherry pick, and they may hear 10, maybe 15% of the cases appealed to them. The Supreme Court has even more stringent standards. They hear less than 1% of all cases that are appealed to them, unless it's original jurisdiction. Original jurisdiction, the Supreme Court has to hear. So, to get to a Supreme Court, to get the Supreme Court to hear your case, the Supreme Court must issue a writ of something called certiorari, writ of certiorari, certiorari, certiorari. Another Latin phrase translates into to make more certain. Okay, let's talk about these writs. Let's talk about this process. You lose at the appellate level. You lose at this mid-level. You decide you want to appeal to the Supreme Court. There are 13 appellate courts throughout the United States. Each Supreme Court justice will act as a circuit justice to these mid-level courts. 9 justices, 13 appellate courts, so some of them have 2. But your appeal initially goes to them. They look at it, they say, you know what, this isn't any question. There's no great constitutional question here. There's no merit to this appeal. They throw it away. Your appeals process is over. Whatever the appellate court decided, that's the final decision. But you get lucky. Your circuit justice says, you know what, this is kind of interesting. This is a legitimate constitutional question. I think the Supreme Court should hear this case. You're only halfway there. About once a week, the Supreme Court, conference call or whatever, they'll get together, and each justice will bring up cases that they think the Supreme Court should hear. So if your circuit justice thinks that your case is worthwhile, it is a constitutional question, it should be decided, they will make that argument to the other 8 justices that the court should hear it. If 4 of the 9 justices, this is called the rule of 4, the rule of 4. If 4 of the 9 justices agree to hear your case, congratulations, you have made it. The Supreme Court will issue that writ of certiorari to make more certain. They're going to send it to the appellate court that has decided your case, and all they're saying is, send us all the paperwork that you have. Send us the court record, send us everything. We want to review it one final time to make sure everything was done properly. So, rule of 4, 4 justices out of the 9 must agree to hear a case. Then they issue a writ of certiorari. What if only 3 of the 9 agree to hear your case? Your appeal process is over. Whatever the appellate court ruled is final. Lobbying for access. Interest in the courts. Interest group, society forces. They will use several strategies to persuade justices to listen to their problems, to rule the way that they want them to. What we see, these lawyers, these group lawyers, they have to plan carefully to bring a case to the court. They have to pick the right client, the right case, the right time, the right district, the right jurisdiction. Publicity helps. Why is this such a big deal? Your overall goal. This is the big deal. 2015, the United States legalized same-sex marriage, so that it must be accepted in all 50 states. Prior to that, it was a patchwork issue. Some states recognized it, some states didn't. And this was an issue because of Article 4, Section 1, the full faith and credit clause. You know, if you're married in one state, you're married in all state. But what if you are a same-sex couple that get married in a state that recognizes same-sex marriage? Then you move to a state that doesn't recognize same-sex marriage. Might be a state in Texas. We actually made it illegal. We passed a constitutional amendment that said same-sex marriage was illegal. So what do you do then? This was the issue. What if you, as a group, what if you want to get your case you want the Supreme Court to say same-sex marriage is legal, it should be legal in all 50 states. Before 2015, before the Supreme Court heard this, where would you start? Would you file your case at a district court, the lowest level, in California, or would you file it in Texas? If you said California, why did you say California? You probably said California because you'll win in California. And this is true. But you don't want to win. You're playing to lose. If a district court, that trial court, makes a decision, it only applies to that district, that physical location. If the circuit court, the Court of Appeals, if the Fifth Circuit makes a decision, it only applies to the Fifth Circuit. It doesn't apply nationwide. You want your case to get up to the Supreme Court because their decisions are going to cover all states. They're going to cover everybody in the United States, all the level court system. So the Supreme Court, they are making decisions that's going to be the law of the land. So you're not going to go to California and file a suit to try and get same-sex marriage legalized, because if you win at the trial level, it stops right there. You go to Texas, and you're going to lose. Texas is a very conservative state. That's okay. You need to lose. You're going to go to the Fifth Circuit. You're going to appeal. You're going to go talk to them in New Orleans. And New Orleans, Fifth Circuit, very conservative. You're going to lose. That's okay. This is what you want. Then, and only then, can you appeal to the Supreme Court. So you actually have to plan this out. You have to, the first two rounds, you have to pick courts that you are going to lose. That is what you want. The path to the Supreme Court is long. Congratulations. Your circuit justice said, yeah, this is a good case. We need to hear it. And they convinced at least 3 other justices to hear your case. Rule of 4 occurs. They issue a writ of certiorari. They tell the lower court, the appellate court, send that paperwork up to us so we can review it. Do they accept it today and say, hey, we're going to hear your appeal, make your argument next week? No, that's not what happens. First step in the process, once the court agrees to hear your case, attorneys on both sides prepare briefs. Briefs are written documents in which attorneys explain, using case precedent, using previous Supreme Court decisions why the court should find in favor of their clients. Supreme Court decisions, these are the law of the land. So if you can say, hey, Supreme Court has ruled previously in my favor using this in this court case, you're supposed to follow this precedent. During this time, while the attorneys on both sides are preparing their briefs, they give it to the justices to review. Now we have these other groups, these other individuals. They can file these amicus briefs that are going to support the claims of either the plaintiff or the defendant. Amicus brief for into the court, yeah, you should rule for the plaintiff for this reason, yeah, you should rule for the defendant for this reason. I asked my students, these 9 Supreme Court justices, do they like getting amicus briefs? Honestly, I don't know. I'm torn. Because I'm sitting here thinking, if I'm a Supreme Court justice, I am one of the 9 most powerful justices in the United States. I am one of the 9 most highest people in the judicial system in the U.S. How dare you tell me what to do? But, on the other hand, if you're giving me court cases and saying, hey, based on previous court decisions, previous Supreme Court decisions, this is how you should rule, man, you've done a lot of my research for me. You've made my life easier. So do the justices like amicus briefs? I'm honestly not sure. Anyway, they file their briefs, the court reviews them. We then have oral arguments. Like I said earlier, oral arguments occur under a strict time limit. Attorneys for both sides appear before the court to present their positions, to make their arguments, and to answer questions posed by the justices. Gonna make this argument in front of all 9. They may or may not ask questions. You answer. Once the time limit is up, the oral argument is over. The attorneys leave. We now go into something called conferencing. Conferencing is simply, after the arguments, the court justices meet to discuss the case. The discussion is kept secret, but they're sitting here saying, okay, I think the plaintiff won for this reason. Somebody else might say, well, that's sound legal reasoning, but what about this? What about the defendant's point? Was this a sound legal argument? Does this override the other one? How long does conferencing take? Conferencing lasts until the court reaches a majority decision. Till the majority of them say, okay, this person won, this person lost. Once this occurs, somebody from the winning side, one of the justices from the winning side, the majority side, will be given the responsibility of writing the opinion. The opinion is the official decision of the court. It says who won, for what reason. The opinion is very important because this opinion sets precedent. It says from this day forward, this is the law of the United States until we, the Supreme Court, change it. So the opinion is very, very important. For the opinion, there are different types of opinion. The first type is something called a majority opinion. Now, this sounds really, really odd in the way I explain it, but you've got to think about this. We have 9 people on the Supreme Court. They're going to conference until they reach, the majority of them agree. So, for the majority decision, it could be a 5-4 decision. 5 agree, 4 don't. Could be 6-3. 6 agree, 3 don't. 7-2, 7 agree, 2 don't. 8-1, 8 agree, 1 disagrees. Could be 9-0. Could be a unanimous decision. Whatever that majority number is, 5-4, 6-3, 7-2, 8-1, 9-0, for each case, there can only be one majority opinion. There can only be one majority. Think about a room full of 51 people. 26, 25, 27, 24, etc., etc. Whatever the number is, there can only be one majority. So only one majority opinion. Now, this majority decision, they'll write the opinion. We can see a second type of opinion. The second type of opinion is called a concurring. 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 A concurring opinion. The concurring opinion, you are saying, I agree with the majority, but I agree for a different legal reasoning. I do not agree with the reason that the majority decision, the majority opinion is giving. Third type of opinion is dissenting. 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 Dissenting opinion. Dissenting opinion, you're saying majority's wrong. Flat out, they blew it. They didn't get it right. My example here, I have 9 of you, and I say the Texans are playing this weekend. They're playing Baltimore. And I say, who's going to win? 7 of my judges say the Texans are going to win. 2 of them say the Ravens, Baltimore. Texans don't have a chance. Okay. I asked my 7, why? My majority opinion, 7-2, is what? Texans are going to win. Explain to me why. Explain to me your reasoning. 5 of them say our offense is that good. We're going to run the ball. We're going to protect the quarterback. We're going to keep the ball away from the Ravens, from Baltimore. We're going to control the clock. This is going to allow us to win a low-scoring game. 5 of y'all are telling me this. I look at the other 2 and say, what do y'all think? They say, no, we're going to win, but we're not going to win because of our offense. We're going to win because of our defense. Our defensive backs are good enough. They're going to prevent the Baltimore quarterback from passing the ball. They're going to be forced to run, and our defensive line is good enough to stop the run. So I have a majority opinion. 7 people said that Texans are going to win, but these last 2, they're going to win because of defense. What kind of opinion did they give me? They gave me the concurring, a concurring opinion. They agree with the majority, but they agree for a different reason. The 2 that said, nope, Texans aren't winning. What kind of opinion is that? That is the dissenting opinion. What can influence decisions? The Supreme Court explains its decisions in terms of law, in terms of precedent. But we see that court justices may make a decision based on two other things. The first thing we're going to discuss is judicial philosophy. What is the job of the court? Judicial philosophy can fall into two categories. The first is judicial restraint. Judicial restraint, this is the judicial philosophy that the judge, the justice, refuses to go beyond the clear words of the Constitution in interpreting its meaning. They are using the Constitution that was ratified in 1789. This is what the framers said. This is what the framers meant. This is the clear meaning of the Constitution. This is what the law is. That's judicial restraint, very strictly interpreting the Constitution. The other type of judicial philosophy is something called judicial activism. Those who practice judicial activism, those who practice this judicial philosophy, claim the court should go beyond the words of the Constitution, or they should go beyond the words of the law and consider the broader societal implications of its decisions. They should say they're going to look at how is this decision going to affect society as a whole. So for the judicial philosophy, does the judge or does the justice practice judicial restraint or judicial activism? This is only half of it. The other half, political ideology. Political ideology, is it going to be a conservative ideology? Is it going to be a liberal ideology? A conservative or liberal attitude? This is going to play an important role in their decision. Now, early on I said that each justice is supposed to be impartial, but can we truly be impartial? Honestly, no, we can't. Why not? Because we all have our own ideas, our thoughts, based on our own life experience. Judges are no different. Justices are no different. Their liberal ideology, their conservative ideology, what role the government should play, is going to affect their decision-making process. We know by past judicial decisions whether a judge or a justice practices judicial restraint, whether they practice judicial activism. Do we know their political ideology? No, we don't, but we think we do. Why do we think we do? How can we tell what a judge or a justice's political ideology is? We can't be sure, but what we do to decide this, to determine this, is we look at the president and their political ideology. Were they a conservative? Were they a Republican? Were they a Democrat? Were they a liberal? We're going to look at the president that appointed them. Would you agree, and remember we've already talked about political ideology, would you agree that conservatives and liberals have different ideas of what the government should do? Yes. When a president appoints somebody to a bench, they're going to give them a lifetime job. Do you think the president's going to appoint somebody who agrees with their point of view or who disagrees with their point of view? The president wants to appoint somebody who's going to agree, who hopefully will agree with their point of view. So this is why we say we can tell a justice's political ideology by the ideology of the president that appointed him. Is this 100% foolproof? No, it is not, but we think it is. It's the best we can do. So, okay, we know which political philosophy, restraint or activism. We know what political ideology based on the president that appointed him. Well, first off, before we go any further, why do we do this? Because we have political scientists who have nothing better to do but sit around and examine these things and try and guess how the court's going to rule. Why don't we just wait? Guys, Star Wars Rise of Skywalker came out recently. You know how many theories I saw online about what this meant, what that meant? Why didn't we just wait to see the last movie? I'm still trying to figure that one out. Why didn't y'all just wait? What fun is that? Let's guess. We're doing this just to try and guess how the court's going to rule. We know their judicial philosophy. We know their political ideology. So, can we accurately guess how the judge or how the justice is going to rule? The answer, no, we can't. It is still very unpredictable. Early on, we talked about Article 3. And I said Article 3 gave two protections to the judges, to the justices, to all three levels. What were those protections? Told you I was going to talk about it again. What were those two protections? Lifetime tenure, can't cut pay. Why are these important? Think about this. Part of the job of the judicial branch is to perform judicial review. Review the acts of the legislative branch, review the acts of the executive branch for constitutionality. Make sure that they are legal to do. Could the judicial branch do this without these protections? You go into work and your boss says, "Hey, I've got this idea. It's the greatest idea. It's going to increase business 300%. They tell you the idea, and it is the worst idea you have ever heard. Then they ask you that dreaded question. What do you think? Yeah. What do you think about this idea? I told you that it's the worst idea you've ever heard. Do you tell them it's the worst idea you ever heard, or do you tell them it's the greatest thing you've ever heard? Most of us are going to say, oh man, this idea is awesome. It's great. We should have implemented it yesterday. Let's get started. Why are we going to lie? Why are we working? Some of us may work because we enjoy it. Most of us are working because we have to. We need to make money. If we go tell our boss, this is the worst idea I've ever heard, what are you, stupid or something? Are you out of your ever-loving mind? Boss is probably going to say, okay, thanks for your honest feedback. You're fired. But we need our job. So we're going to tell them, we're going to lie, say it's a great idea. Well, how does this apply to the branch, judicial branch? Imagine the court telling Congress, no, this law is illegal. It's unconstitutional. You can't do it. And Congress says, okay, that's fine. Oh, by the way, we're cutting your pay. Oh, by the way, judges that disagreed with this, that said this was unconstitutional, you're fired. Without these two protections from Article 3, could the court system, could they use that power of judicial review taken from Marbury versus Madison, and could they use it effectively? Could they use it freely? No, they couldn't. Because of this, there is some unpredictability in guessing and trying to predict how the judges are going to rule.